Hi, I'm Keith Grossman with Grossman Law and Conflict Management. These videos were created and produced to help you understand some of the basic things in a divorce case in Florida. We hope that you find them helpful, and if you want more information, you can go to www.attorneygrossman.com. Here is a brief overview of a traditional type of divorce in the state of Florida. So, what is it that you really need to know for a traditional divorce case? Well, here are the steps in the divorce. First, the person who wants to file for the divorce is going to file what's called a petition. It gets served on the other person, and they have 20 days to file a written answer. They may also decide to file a counter petition, and if they do so, the other person, the original person who filed the petition, has to then file a written answer to the counter petition. The petition and the counter petition are the documents that are basically your wish list, telling the court what it is that you want to be done at the end of this case. Other steps in the process include what is called discovery. That is where both sides exchange documents and maybe some other information. In Florida, there is a rule that is called mandatory disclosure, and that rule defines different documents that are required to be exchanged in a divorce case. During the divorce process, you may also decide that you have to file some motions or maybe do some legal research to prepare your case for a hearing or for a trial. An example of a motion might be if you want the judge to do something while the case is pending before you have your final trial in the case. You would file a motion and schedule a hearing on your motion. Of course, while the case is pending and discovery is being exchanged and any motions are being heard or research being done, attempts are being made at settling the case. Attempts at settlement could include going to mediation. Most jurisdictions in Florida will require you to attend mediation before you can have a final trial in your divorce case. Ultimately, if you do not settle the case, then you'd have to go in front of the judge to have a trial so that all matters can be heard and the judge can make a decision on the final rulings in the case. Here are the legal issues in a divorce case, and most judges follow this order because each of them impact the other. The first thing the judge will consider is all parenting issues. This is the amount of time the children will spend with each parent, which parent will be making the decisions if shared parental responsibility is not being ordered. The next thing the judge will consider is what's called equitable distribution. This is how the court will divide up the property, which includes all marital assets and liabilities. The next thing would be for the judge to determine alimony, if any will be paid and how much. The next part is child support. In Florida, we have child support calculations. There's certain information that you plug into the calculations, and it gives you that final number of what the child support amount is. And then after that, everything else that needs to be decided that does not fall under one of the other categories. A word on the idea of parenting. We commonly know this idea as custody and visitation, which are actually concepts no longer used in the Florida laws. When it comes to making decisions about the parenting time, the judge wants to know about each parent's desire to encourage the other parent's relationship with the children. The judge has to make a decision that is in the best interest of the children, and knowing that one parent will do a better job of encouraging and fostering a relationship between the child and the other parent is a very important thing for the judge when making any decisions. Concerning child support, we do have Florida statutes guidelines that will help determine what the child support amount should be. These guidelines are driven primarily by the income of the parents. They will also take into account the cost of child care and the cost of any health insurance. There is a worksheet for the purpose of using these guidelines. My simple example here, which is not consistent with what the actual child support guidelines say, but just intended to be easier to understand. The idea here is that between both parents, if they have an available income, which for most people is net income, of a combined income of $1,500, and they have 2 children, then under this example the child support amount would be $700. If each parent makes 50% of the available income, so they are both contributing $750, that same 50% is applied to the child support amount. So each parent would be deemed to be paying $350, or 50% of that $700. You then start taking into account the cost of the child care, the cost of the health insurance, and if there has been a parenting time schedule that gives both parents more than 20% of the time, that would have an impact on the amount as well. In order to prepare the judge to make decisions for child support and for alimony, both parties are required to file financial affidavits in all divorce cases. These affidavits are signed under oath, so they need to be truthful and they need to be accurate. If your expenses are more than your income, then you need to be prepared to explain why that is and how you are living if you're not making enough money to pay all your expenses. You can footnote your financial affidavit and explain certain things about your income, certain things about your expenses. If you are in a living situation where your expenses are not what you expect them to be because you're going to be moving or something else is going to change, you can footnote that these are projected expenses as opposed to them being your actual expenses. You want to make sure you update your financial affidavit regularly because it is common for income and expense situations to change while a divorce case is pending.